Good. Great. So tonight, I'm going to look at the functions and responsibilities of three different planning bodies in New South Wales, Victoria, and Tasmania. Going to look at their functions and responsibilities, particularly in respect of public participation and the planning framework. Going to have a look at the approach of those bodies to the conduct of public hearings and the testing of expert evidence. Draw on those findings to think about some opportunities for reform. Briefly look at some case studies that show these planning bodies in action, and conclude with some final takeaways. And this presentation tonight is based on an article that I've got coming out that I co-wrote with a few of my former EDO volunteer researchers in the Australian Environment Review. So do keep your eyes peeled for that. That should be coming out in the next week or so. So we begin by looking at the functions and responsibilities of various independent planning bodies. But before we do that, let's reflect for a moment on the importance of public participation in a public hearing. Now, it's been said that participation by citizens in the governance of their society is the bedrock of democracy. This is so because of four different aspects of the public hearing. Firstly, a public hearing is an institution that is invaluable to any democracy because it allows citizens to access information about important public policy. Secondly, it provides citizens a way to be consulted. Thirdly, it allows them to participate in the decision-making process as part of the public hearing. And fourthly, it allows decision makers and proponents to be accountable to the public. So public hearings are very important for public participation in our democracy. Now, when I talk about independent planning bodies, I want to be clear that the focus of tonight's presentation and of my Australian Environment Review article is on particular types of independent planning bodies. So I'm focusing on independent, executive, merits, first instance decision makers or recommendatory bodies for major or state significant projects. So I'm excluding the Minister for Planning in my consideration. And at the outset there, you can see that I'm focusing on the Independent Planning Commission in New South Wales, which is both a consent and a recommendatory body. I'm not focusing on local planning panels or Sydney and regional planning panels. In Victoria, I'm going to analyse Victorian planning panels and environment effects inquiries, which are both recommendatory. They both make recommendations to the Minister for Planning or to the relevant responsible authority. And in Tasmania, the Tasmanian Planning Commission, which has both consent and recommendatory functions. I'm focusing on these three or four. The reason why I say three is because Victorian planning panels and environment effects inquiries are administered by Planning Panels Victoria, and the procedures that apply to Victorian planning panels and environment effects inquiries are relatively similar. So the focus is on these four or so apex bodies as first instance decision makers or recommendatory bodies in a planning system. So I want to take you through some of the key functions of these bodies, just at a really high level. The IPC is governed primarily by the EP&A Act, the Environmental Planning and Assessment Act, among other acts and other regulations, but this is its primary act. And its functions, as you can see, are on the screen. It has the functions of a consent authority under Part 4 of the EP&A Act for state significant or other development conferred on it. any functions under the Act that are delegated to the IPC. It has that advisory function to the Minister or Planning Secretary. It can hold a public hearing, which we're going to focus on tonight. And it's got any function of a Sydney District or Regional Planning Panel or Local Planning Panel in respect of the particular matter that the Minister requests.
Matt, sorry to interrupt. I think there's some people in the waiting room, if you're able to admit those.
Thanks. I've just seen a message from James. Yes, I've admitted Lindsay now. Thank you.
Great.
So the IPC as a consent authority, let's just focus on that for a second. It's important to note that in the context of New South Wales, the IPC can act as a consent authority upon the Minister for Planning's direction. In this sense, the IPC functions as a quasi-judicial body, albeit within the executive branch of government. The IPC can only hold a public hearing in two circumstances. First, where the Minister directs the IPC to do so in respect of state, significant or other development. And secondly, where the Minister has determined in the gateway determination, which is a preliminary planning process within the Department of Planning, Industry and Environment, that the IPC is to conduct a public hearing into a planning proposal for the provisions of a local environmental plan. And LEPs are otherwise known as planning schemes in Victoria and Tasmania. So the first circumstance is the more fundamental role of the IPC, in my view, in respect of state significant development, and it's that which we're going to focus on tonight. Conducting a public hearing to promote effective community participation in planning decisions is therefore to an extent reliant on the Minister's discretion. However, the community is able to potentially push for a public hearing through the submission of those objections, which you can see are enumerated on the screen. It's also important to note that in New South Wales, when the IPC conducts a public hearing, a decision of the IPC for that development proposal, that development application, is not subject to any merits review. So in effect, the public hearing extinguishes the right to merits review, which would otherwise be available in the New South Wales Land and Environment Court. Therefore, the public hearing represents the final opportunity for the proponent, any objectors, or other stakeholders to present evidence of the substantive merits of a proposal. As most of you would know, after a public hearing, public interest litigants, including those represented by my Community Legal Centre, the EDO, are limited to challenging a proposal through the straitjacket of judicial review. I do note briefly that there is an important difference between what the IPC calls a public hearing and a public meeting. A public hearing held by the IPC will extinguish merits review rights, as I've just discussed. However, a public meeting held by the IPC will not extinguish those merits appeal rights. So, for example, for the Rocky Hill litigation that I was involved in, the IPC's predecessor, the Planning Assessment Commission, held a public meeting rather than a public hearing, which preserved merits appeal rights for both the proponent in that case and also any other objector, including EDO's client, Groundswell Gloucester. So with that in mind, let's turn now to the Victorian and Tasmanian planning framework and the operation of their respective planning bodies. So, Victorian planning panels and environment effects inquiries also form part of the executive branch of government, relatively quasi-judicial in that broad sense of the word, but are recommendatory they make recommendations to the Minister or the responsible authority in respect of, as you can see, there are various things. So Victorian planning panels are appointed by the Minister to conduct public hearings in relation to proposed amendments to planning schemes, combined permit and planning scheme amendment processes, or planning permit processes. And planning permits are otherwise known in New South Wales as development consents. Environment effects inquiries deal with those big projects, those big development applications or big planning permits, appointed by the Minister to analyse the environmental effects of any proposed works, including major road projects, significant port and marine infrastructure, and large energy and mining projects. So, although both Victorian planning panels and environment effects inquiries do not themselves make determinations of consent, but rather make recommendations to the Planning Minister, both bodies have clearer and more rigorous legislation and policies compared with that underpinning the IPC. The Tasmanian Planning Commission is also a statutory body, similar to its New South Wales and Victorian equivalents. However, the TPC is different in that it is a body with a standalone statute specifically created to define its functions and responsibilities. As a result, there is greater statutory clarity in its processes when compared with the other jurisdictions. As you can see on the screen, the TPC performs dual functions within the Tasmanian planning system by engaging in both advisory and consent authority roles under its Act. For example, the TPC may appoint a panel to determine assessment of major projects, make recommendations to the Premier on projects of state significance, report on draft state policies and Tasmanian planning policies, and so on. On the screen, there is an excerpt from Section 6 of the TPC Act, which variously details some of the functions that accrue to the TPC, including providing advice and support to the Minister in relation to their powers, planning for the coordinated provision of transport and infrastructure for land development, providing advice to local government, and reviewing and advising the Minister regarding state and regional strategic land use matters. So with that background in mind, let's now turn to the way that these bodies deal with the conduct of their public hearings. It's my view, and the view of my co-authors, that an ideal public hearing is one that facilitates meaningful public participation in its processes by firstly having clear procedural guidelines for both pre-hearing processes and the hearing itself, making provision for certain types of evidence to be taken on oath or affirmation, and ensuring that such evidence is subject to rigorous testing. I note, particularly for the provision of evidence to be taken on oath or affirmation, that the receipt of evidence on oath or affirmation is a requirement that may bolster the integrity of evidence received during the hearing. For example, by discouraging practices such as providing false or exaggerated information that may detract from the integrity of the evidence received during public hearings. With that in mind, let's have a look firstly at how the IPC approaches its public hearings and the statutory and policy framework behind that. Looking at the IPC, while Clause 8, Subclause A of Schedule 2 of the EPNA Act states that regulations may provide for the procedures of the Commission, including the procedures for public hearings, the corresponding regulations, the EP&A regulation, is silent on IPC public hearing procedures. There are, however, public hearing guidelines for the IPC available on the IPC's website. However, the detail provided is arguably more limited compared with that in Victoria and in Tasmania. This makes it more difficult to understand the procedures and in turn facilitate meaningful public participation. Notably, there is no explicit provision in either the EP&A Act or the EP&A regulation that gives the IPC a general power to give directions about the conduct of its public hearings or hold directions hearings. However, it may be argued that the IPC has a general power to give directions about the conduct of its public hearings as an incident of its power under section 2.9, subsection 1D, to hold a public hearing into any matter into which the minister requests the Commission to hold a public hearing. The legislative framework for the IPC similarly fails to provide for the receipt of evidence on oath or affirmation, a requirement, as I said earlier, that may bolster the integrity of evidence received during the hearing. Unfortunately, the legislation policies underpinning the IPC's conduct of public hearings, in my view, are light on detail, unclear at times, and insufficiently rigorous compared with the legislation policies relating to Victorian planning panels and environment effects inquiries and the Tasmanian Planning Commission. Another issue regarding the IPC's approach to the conduct of its public hearings, well, in its legislation, in its founding statute, is that there is no express statutory requirement for the IPC to observe the rules of natural justice or procedural fairness. The only protection for procedural fairness during an IPC public hearing is the common law duty imposed on all administrative decisions to accord procedural fairness where a decision will affect an individual's rights, interests, or legitimate expectations, as held in Kiowa and West. In the context of the public hearings, it is certain that the IPC's determination of a development application will affect an individual's rights, interests, or legitimate expectations, such as those of the proponents or the objecting or supporting public. As a result, the IPC is under a duty to ensure procedural fairness in the public hearing process. And this duty is further supported by the absence of any contrary statutory intention in either the EP&A Act or the EP&A regulation. However, it must be said that the silence of the legislative framework on the IPC's duty to afford procedural fairness may create an ambiguity that leaves the duty vulnerable to challenge. Accordingly, the preferable approach is that adopted by the Victorian and Tasmanian legislation, which effectively enshrines expressly the rules of natural justice and procedural fairness in legislation that governs those bodies. Turning to the Victorian planning panels, and as discussed earlier, they're appointed by the Minister to conduct independent public hearings in relation to statutorily defined matters. The Planning and Environment Act in Victoria, the P&E Act, provides significantly more detail than its New South Wales equivalent, the EP&A Act, in respect of defining the role of Victorian planning panels and its ability to give directions about the conduct of public hearings. Notably, a panel is able to give directions about the conduct of hearings, including whether they will be conducted in person or by audio-visual link, and a panel is also able to give directions about matters preliminary to hearings, such as whether a directions hearing is required. Note that the ability to provide a directions hearing of the IPC is not currently in its public hearing guidelines or in its legislation. Back to Victorian planning panels. So there are several guides available on the Planning Panels Victoria website that assist the public and proponents in understanding how Victorian planning panels are conducted. It is evident that the legislative framework in Victoria provides greater assistance in defining the roles of its public hearings and the procedures that accrue to those public hearings. Some of the guides on the Planning Panels Victoria website include what is a panel, guide to the public hearing, and expert witnesses, detailed guides that are publicly accessible. Delving a little bit deeper into the P&E Act in Victoria. Section 167 of the P&E Act states that a panel may regulate its own proceedings. Section 161 of the P&E Act states that a panel must do X, Y, Z, as you can see on the screen, and is bound by the rules of natural justice under subsection B. So a Victorian planning panel is allowed to regulate its own proceedings, and that's made express. This discretion extends to the matters addressed earlier, such as conducting directions hearings, but could also be the reason for the detailed guides available on Planning Panels Victoria website that allow for greater clarity for the public. The P&E Act also provides various rules for a panel when conducting a public hearing, as you can see on the screen. These are all integral elements in fostering public participation and public confidence in decision-making processes, particularly not being bound by the rules of practice and not being required to conduct the hearing in a formal manner. This removes some of the legal technicalities that would otherwise apply in traditional court proceedings. The express protection of the rules of natural justice acts as a support for the community and for the panel in making its decisions. And that is contrasted with the position in New South Wales. An environment effects inquiry is a separate process to Victorian planning panels, although is facilitated by the same body, Planning Panels Victoria, and exists to analyse the environmental effects of any works or proposed works to which the EEA Act applies. The works that could come under this umbrella would likely be considered state significant development in a New South Wales context, including major road projects, significant port and marine infrastructure, and large energy projects such as power stations, wind farms, and large mining projects. A key difference between a Victorian planning panel and an environment effects inquiry is that the minister is responsible for laying down the guidelines for conducting an environmental effects inquiry. The minister is afforded a wide discretion to make these guidelines, but they are to be made with the purpose of enabling the carrying out of the Act. According to the What is a Panel guide on the Planning Panels Victoria website, similar procedures are to be followed for both Victorian planning panels and environment effects inquiries. This is important in enabling the community to understand the procedures of an environment effects inquiry, as the legislation is somewhat brief in guiding the conduct of the inquiry compared to the P&E Act and its scope, its express provisions for Victorian planning panels. Moving further south to Tasmania. So the TPC, its functions are relatively similar to those exercised by the New South Wales IPC. However, as mentioned earlier, arguably, the legislative framework provides greater clarity in respect of the rules for conducting a public hearing. Notably, the TPC Act enables the TPC to take evidence on oath and on affirmation, which can reduce those issues, as I mentioned earlier, with evidentiary integrity. Further, as you can see on the screen, the TPC has created very detailed practice notes, very helpful, that outline the procedures for conducting its public hearings, including in respect of receiving expert evidence, which I'll discuss a bit later in the presentation tonight. Delving a little bit deeper into the legislation underpinning the TPC, Section 10, subsection 1A of the TPC Act states that the procedure of the TPC is to be determined by the Commission. And subsection 1B states that the TPC must observe the rules of natural justice. So you can see similar to the provision under the P&E Act about the requirement to keep to the rules of natural justice. This demonstrates that both in Tasmania and in Victoria, there is that statutory preservation or at least guideline to observe those rules, and that's seen in contrast to the absence of that express provision in New South Wales. Stepping back a bit now and looking at opportunities for reform. And most of these opportunities relate to my home state, the IPC, and its legislation and policies and procedures in New South Wales. The comparisons between the different jurisdictions highlight that the New South Wales legislative and policy framework for the IPC could be strengthened, could be made more robust to improve the IPC's public hearing process, facilitate public participation, and improve the rigours of the New South Wales planning system. The comparison tonight has revealed that the IPC's conduct of public hearings is light and unclear in three areas: its ability to give directions about the conduct of its hearings, including to hold directions hearings, its ability to take evidence on oath or affirmation, and the lack of an express requirement to observe the rules of natural justice in the public hearing process. The Victorian and Tasmanian Acts effectively clarify the powers of their independent planning bodies to conduct hearings in the way that they determine, including regulating their proceedings and ordering that a directions hearing be conducted. Further, it would be beneficial for the equivalent of Section 161 sub 1 of the P&E Act or Section 10 sub 1B of the TPC Act to be enacted in respect of the IPC, particularly an express requirement for the IPC to observe procedural fairness. Again, reiterating that point there. Something that could also be useful for the IPC would be to create practice notes to assist the proponent, the community, and other stakeholders. And it could also be useful for Planning Panels Victoria to refashion or reframe some of its guides on its website as more formal practice notes. Turning to the second part of my presentation tonight, so the testing of expert evidence. My co-authors and I believe that expert evidence can, firstly, elucidate issues of technical complexity for the benefit of a decision maker. Secondly, provide a basis on which a decision maker can make an evidence-informed decision. And thirdly, increase public confidence in the public hearing process. There is a difference between evidence-informed public policy decision-making and evidence-based public policy decision-making. The terminology evidence-informed decision-making takes into account that sometimes, often, particularly in a planning context, evidence can be contested, as I'm sure that many of you will realise practicing in this space. So it's important that the decision maker makes a decision that is best informed by the best available evidence. When commissioned independently by an objector, expert evidence may serve as an important counterpoint to the evidence tendered by either the proponent or the department, who in several instances may be in favour of a particular development application by the private sector. So looking at the provisions for expert evidence across the 3 jurisdictions. Despite the importance of expert evidence, as I've outlined, unfortunately, there is no express reference to expert evidence in the New South Wales EP&A Act, regulation, or the IPC public hearing guidelines. There is reference to evidence in the public hearing guidelines, but not particularly and in-depth expert evidence. This is, of course, a serious omission in the legal policy framework, in my view, as it means that the IPC's approach to expert evidence can be unclear to persons appearing before an IPC public hearing. In contrast, Victoria and Tasmania both have expert witness provisions, specifically the Planning Panel's Victoria Expert Witness Guide and the Tasmanian Planning Commission Practice Note 14. Key areas, therefore, for the improvement of the New South Wales IPC's legislative and policy framework include clarifying the duty and role of expert witnesses, providing for expert witness statements and directions hearings, providing for joint expert reports and peer review of expert evidence, and allowing cross-examination of expert evidence. Let's have a look at some of the examples in Victoria and Tasmania. So, looking at the Expert Witness Guide for Planning Panels Victoria. Planning Panels Victoria has produced the Expert Witness Guide, which sets out a rigorous approach in respect of the duty and role of expert witnesses. This includes expressing the requirements of an expert witness's duty to the panel, as you can see on the screen, stating that the paramount duty of an expert witness is to assist the panel. The guide therefore reinforces that the expert witness is not an advocate for a particular party, imploring experts to include all evidence, even if it may be unfavourable to the party that engages them. Similarly, in Tasmania, Practice Note 14 imposes duties on expert witnesses to provide independent expert advice that might not be favourable to their engaging party. This is an integral element of their process. As I noted earlier, there is no equivalent of such provision either in policy or in statute for the New South Wales IPC. Looking at expert witness statements and directions hearings, there's a summary on the screen there that compares the Victorian guide and the Tasmanian practice note, both of which set out requirements for the preparation of expert witness statements. Moreover, both provide that a directions hearing, where held, should discuss the evidence that parties wish to call at the public hearing, which ensures that all parties are apprised of the arrangements for expert witnesses at the public hearing and the nature of the evidence to which they will need to respond. The legislation and policies underpinning the IPC public hearings, however, do not expressly refer to the requirement for expert witness statements. And as I noted earlier, don't expressly provide for directions hearings. Joint expert reports and the peer review of expert evidence. Planning Panel Victoria's Expert Witness Guide allows the panel to direct that expert witnesses in the same technical area meet before the hearing and prepare a statement of agreed opinions and facts. This is so that experts can identify and, if possible, reduce areas of disagreement in the hearing, which ensures a more efficient and effective process. The Tasmanian Practice Note 14 is similar in its approach. It states that its procedure in directing a peer review of an expert's witness evidence, that is an integral part of the process. In my view, that's positive, although it could be strengthened, again, in my view, by allowing the TPC to direct a peer review where there is more than one expert. In contrast, there's no explicit reference to joint expert reports or peer review of expert evidence in the legislation and policies underpinning the IPC. However, I note that I have seen that the IPC sometimes seeks peer review of its own accord of evidence. However, that's not made a requirement in either its legislation or policy. That's in its own discretion. Cross-examination. Significantly in relation to the cross-examination of witnesses, Section 161 sub 3 of the P&E Act in Victoria allows a Victorian planning panel to prohibit or regulate cross-examination in any hearing. In this regard, Victorian Expert Witness Guide for planning panels and environment effects inquiries permits the panel to allow for cross-examination of expert witnesses. The questions that are put to expert witnesses must be relevant, directed to matters of fact or professional opinion, and must genuinely assist the panel in understanding the issues, as you can see there on the screen. In my view, this is a commendable approach, as it allows for more rigorous testing of the expert evidence, particularly through cross-examination by the parties, which enhances public participation in the public hearing. A point for improvement for the TPC is that currently the TPC is silent as to its procedure regarding cross-examination of expert witnesses. There's an excerpt there from the New South Wales IPC public hearing guidelines, which unfortunately, in my view, state that no questions or cross-examination will be permitted from others in attendance, although the IPC allows, of course, panel members and its counsel assisting to ask questions of speakers at a public hearing. But the same right is not afforded to members of the public in attendance or to the proponent or to the department. So there's an opportunity, therefore, for reform. I've noted some minor, in my view, opportunities for reform for the Victorian and Tasmanian examples, but in my view, most of the opportunities for reform are in my home state. So in my view and my co-author's view, the IPC could produce a practice note, specifically dealing with expert evidence. It would be desirable for this to cover things like a description of the duty and role of expert witnesses, an outline of the requirements for the preparation of expert witness statements, provision for the panel to direct joint expert reports and peer review of expert evidence, which would save time and money, and provision for the parties to cross-examine expert witnesses, as they're able to do in Victoria. These measures would enable the IPC to test expert evidence with greater rigor and improve public participation. Moving to the penultimate part of my presentation tonight. So I just want to briefly give you a flavour for how these bodies are dealing with some major projects, not necessarily to criticise what they're doing, but just give members of the audience tonight just a flavour for how they approach major projects. Recently, EDO represented its client Undermine Incorporated in respect of its opposition to the Tahmoor South Coal Project. This was a proposal to extend the Tahmoor coal mine underneath more parts of land near the township of Tahmoor. The project was referred to the IPC by the department. Panel members were nominated by the chair of the IPC. The department conducted a public exhibition process, and the IPC conducted a site and locality inspection and held meetings with various stakeholders. For the public hearing for the Tahmoor South Coal Project, so the IPC conducted a 3-day electronic public hearing, appropriate during times of COVID, from 15 to 17 February 2021, hearing from 88 registered speakers Key issues raised during the public hearing included the project's impacts on subsidence, surface and groundwater, biodiversity, air quality, cultural heritage and greenhouse gas emissions. At the public hearing, the IPC also had counsel assisting or senior counsel assisting present at that panel, at that commission hearing. The IPC received various submissions and numerous submissions, as you can see, in written form. The IPC allowed for the evidence of lay objectors, members of the public, supporters of the mine, the proponents and the department to present evidence to it. This, however, did not follow a specific regimen for the receipt of expert evidence compared to, let's say, the expert witness guide in Victoria. Nonetheless, the IPC took those views into account and as a positive point for the IPC, it does have a good practice of making much of that evidence, if not all of it, available online, including transcripts. A wind farm of up to 104 wind turbines and associated infrastructure. The Minister decided in 2013 that an EES was required for the proposal, having regard to biodiversity impacts, scientific and landscape impacts, and cumulative adverse effects. The proponent prepared a consultation plan outlining the opportunities for community engagement during the preparation of the EES. And the Minister released draft scoping requirements, which were exhibited for 15 days before being finalised. And there was a public exhibition process for 30 days. The inquiry process was, in my view, well publicised. There was a specific website available. Moreover, there was a directions hearing. So at that directions hearing, the Environment Effects Inquiry determined the necessary arrangements and the timetable for the public hearing. That was held in September 2015. The public hearing proper took place between 6 and 20 October 2015, 9 days. And it provided its report to the Minister on 11 January 2016. So again, it's recommendatory, it's not a consent authority, after which the Minister concluded that process. As to its public hearing, the panel members were appointed by the Minister for Planning. As I said, the main hearing was conducted over 9 days and many written submissions were received. Issues related to biodiversity, noise, health, traffic, economic, land use, surface and groundwater, landscape, visual. And the inquiry had terms of reference and it made 18 recommendations to the Minister supporting the project's approval. Interestingly, for our purposes, the proponent called 8 expert witnesses relating to those areas on the screen. And the inquiry report discusses expert evidence in relation to each area, noting that the relevant evidence given and using the evidence to inform its reasoning. Unfortunately, it doesn't appear that copies of expert witness statements were provided by the department, so perhaps that could be an opportunity for improvement. But this process demonstrates the importance of Planning Panels Victoria's expert witness guide. Moving further southward to Tasmania. So 2 quick examples here, and then we'll close with some final takeaways. The TPC has relatively recently been set up. So there isn't a plethora of examples of major projects it's dealt with. I'll get to that point in a moment. But it has considered amendments to planning schemes. So it considered, for example, an amendment to the Launceston interim planning scheme. This proposed amendment was going to allow for the subdivision of land into 30 lots and subsequent housing development. The TPC received a report from the department detailing the public representations made, issued direction letters to gather additional information, and held a public hearing to consider representations and expert evidence. This public hearing was held at its office in Hobart and also by video conference. And the TPC was required to consider public representations in making its decision. 5 experts attended the public hearing, provided evidence in relation to land demand, supply, traffic, agricultural and land supplied issues. The TPC considered the expert evidence, requiring the applicant to carry out development in accordance with those various assessments. It seems that the TPC's first major project that it's going to determine is the new Bridgewater Bridge, just north of Hobart proper. And this is apparently the first time that the TPC, will be tasked with making a determination under the Land Use Planning and Approvals Amendment, Major Projects Act. So the proposal is for a new 4-lane bridge with the state as the proponent. The Minister has provided a notice to the TPC that the development is declared a major project. The TPC members have been required to sign a disclosure of interest form in relation to the project. The TPC determines the assessment criteria for the proponent to address in the major project impact statement, and the hearing is to come. So we will wait and see. So those examples give us a flavour of how these bodies, New South Wales, in Victoria, in Tasmania, are approaching major projects and potentially some opportunities there for improvement. We must consider the importance of a mandatory extinguishment of merits appeal rights after the IPC holds a public hearing. It is vital that independent planning bodies conduct a public hearing process that is firstly clear, secondly robust, and thirdly facilitates effective and efficient public participation. Victorian planning panels and environment effects inquiries and the Tasmanian Planning Commission are not perfect, but are examples of better practice. And this point is made even more clear when we consider that the IPC is a consent authority, obviously with advisory and recommendatory functions, whereas Victorian planning panels and environment effects inquiries are recommendatory. And yet, in my view, they've got stronger requirements than the IPC. Common to all of these bodies, however, is that they are part of the executive branch of government, although they function as independent bodies, independent statutory authorities. So there is room, I think, and in my co-author's view, for some cross-jurisdictional policy learning and legislative learning. Just to recap, the improvements that could be made to the IPC's legislation and policies concern directions about the conduct of public hearings, taking evidence on oath or affirmation, the express requirement to observe the rules of natural justice, and issuing a practice note about expert witnesses' role and duty, expert witness statement requirements, provision for joint expert reports and peer review, and provision for parties to cross-examine expert witnesses. Improvements could be made to Victorian planning panels and environment effects inquiries regarding potentially reframing the guides as practice notes and publishing copies of expert witness statements where perhaps in the past it has not done that. And in Tasmania, because the TPC is fairly new, I only have one point at this stage, which is potentially the TPC providing for the cross-examination of expert witnesses. Thank you very much.
Matt, thank you so much for your thoroughly researched and very insightful presentation. I know that myself, being from Western Australia, I've learnt a great deal today about independent planning commissions in New South Wales, Victoria and Tasmania. So thanks again. And thanks everyone for joining us today for this presentation. As I said earlier, we'll make a recording of the presentation available on our website through the special publications link. I haven't received any questions in the chat, but we do have 2 minutes until the end of the session. So if anyone does have any questions, please, shout out, don't hold back.
Happy to answer any questions from the audience, Jess, and thank you again to NELA for allowing me to give this presentation. It's a pleasure to serve on NELA's board, and love working with the board and my colleagues there. Please don't hesitate to reach out after this presentation via LinkedIn. You can connect with me there, or via my email, which I'll put into the chat, but open to any questions.
Great. Okay. Well, I've got a question from Hannah, which is, will you be circulating the slides? Is that something that you're open to do, Matt?
I'll just have to check with my principals, with my superiors, but leave that one with me. Okay.
If we're able to publish or share Matt's slides, I will, or NELA will send an email to all of the attendees today with a copy of those slides. So keep an eye out for that. So we've just hit 7 o'clock. So we'll end the webinar here. But thanks again, Matt. And yeah, thanks everyone.
No worries. I could see that C. Osborne had their hand up. I just wanted to check whether they want to say something.
No, I didn't.
No worries, sorry.
Okay.
Thank you, everyone. Have a great night, and thank you, Jess.
Thank you. Bye now.
Good night. Bye-bye.
Thanks, Matt.